Welcome to Public Counsel's presentation on the basics of discovery. A few tips and caveats. This video is for educational purposes only. It is not intended to be legal advice for your particular situation. Also, this video only covers the rules for the Central District of California. The Central District Court is the federal district court or the federal trial level court covering the greater Los Angeles region. And lastly, for advice on your particular situation, you should consult an attorney who can review your facts and discuss your options. Discovery is the formal process through which parties in a lawsuit exchange information regarding the evidence, witnesses, and legal arguments they will present at trial. The Federal Rules of Civil Procedure 16, 26 through 37, and 45 provide the general framework for discovery, as well as impose several mandatory discovery obligations on parties. Additionally, you should regularly consult the court's local rules and orders issued by the judge in your case for any additional guidance about discovery. Using tools of discovery, such as interrogatories, requests for production, requests for admission, depositions, and subpoenas, can help you obtain evidence for your case. Informal discovery, such as researching your opponent on the internet, searching publicly available documents, and talking to people who are not parties to the lawsuit, may also provide valuable information about your case. The discovery process is the way either party can gather facts, documents, and evidence to support their claims and defenses. By obtaining and disclosing this information, each party can assess their positions, make informed decisions about proceeding with litigation, and explore potential settlement options ahead of trial proceedings. For example, if you have filed an employment discrimination case, you may need employment records or business agreements to prove your claims. Discovery is the formal way of obtaining those documents from another party, or even from a person or entity that is not a party to the case. Generally, you can use discovery to obtain information that pertains to any of the claims or defenses in your lawsuit, as long as the information is not legally protected under attorney-client privilege or any other law. However, some discoverable information may be subject to privacy concerns or special privileges and will require a protective order before disclosure. You use discovery to find out things like what the other side plans to say about an issue in your case. What facts or witnesses support their side? What facts or witnesses support your side? And what information or documents could be used as evidence? Some more specific examples of facts, documents, and evidence that can be obtained through discovery include business records related to the disputes in your case, names of parties and potential witnesses, government agency records, employment contracts, information about a business's hiring and firing practices, and information about the personal, educational, and professional background of a potential witness in your case. The discovery process allows someone to gather information and documents not just from the parties involved in their lawsuit, but also from non-parties, i.e. individuals or entities not directly connected to the case. Let's explore some of the most common types of discovery tools you can use. Interrogatories. These are written questions directed to the opposing party, requiring them to respond under oath. Governed by FRCP 33, interrogatories are a powerful way to obtain detailed information. However, it's important to note that this tool cannot be used to gather information from non-parties. Requests for production of documents. If you need to obtain documents or electronically stored information from a party, requests for production, governed by FRCP 34, are the way to go. But if your goal is to acquire such evidence from a non-party, you will need a subpoena duces tecum, governed by FRCP 30 and 45, requests for admissions. When you want to secure a written admission regarding the truth of a statement or fact, you will use requests for admission, which fall under FRCP 36. Remember, these can only be directed towards parties involved in the case. Depositions. To capture oral testimony from a party, depositions are conducted under the guidelines of FRCP 30. For non-parties, a deposition subpoena should be issued, also following FRCP 30 and 45. Depositions are formal, sworn testimonies taken outside of court, playing a vital role in the pretrial phase. By understanding these discovery tools and their governing rules, you can effectively gather the evidence and information you need throughout the discovery process. This chart outlines from whom you can obtain discovery from and what specific tools or forms are necessary to obtain the different types of discovery. Let's turn to a case scenario example to demonstrate what kinds of information can be obtained through discovery in a particular lawsuit. Here is the case scenario. Jane, an African-American woman, worked at an advertising agency for 5 years and consistently received positive performance reviews. However, when a management position opened up, it went to a less qualified white male colleague. Following this, she files a lawsuit under Title VII of the Civil Rights Act. Some examples of information she could gather during discovery include employment records like performance reviews and records of salary increases, her company's HR policies for hiring practices, and data about the racial and gender demographics of employees in similar roles to compare promotion rates. So when does discovery begin? The discovery process begins only after you have held the conference of the parties with your opposing counsel or your unrepresented opponents, which is governed by FRCP 26. Once the defendant responds to the complaint, the plaintiff or defendant can initiate this conference. The parties must meet as soon as practicable, and at least 21 days before a scheduling conference is to be held, so it is strongly recommended that you take the initiative and plan the conference of parties. And when does discovery end? The court will likely impose a date for the end of discovery. You may find this deadline in the court's standing order, scheduling order, or any other order related to your scheduling conference. It is important to read everything on your docket and judges' web pages so that you will know whether any discovery deadline exists in your case, as court order may have some different rules. Here are some important resources to refer to during the discovery process. First, we have the Federal Rules of Civil Procedure. These rules govern civil legal proceedings in the United States and provide a framework for conducting lawsuits in federal court. Then there are the local rules of the Central District of California. These rules tailor the federal procedures to the local context and outline specific requirements and practices for cases heard in this district. Finally, you should familiarize yourself with the judge's rules and procedures. Each judge may have unique preferences and requirements, which you can review at the same Central District Court website to ensure that you comply with their specific guidelines. You can find all of the clinic's guides about discovery on our website, along with more information about the Federal Pro Se Clinic and how to request our services. If you need help, please visit us at Public Counsel's Federal Pro Se Clinic. The clinic offers free legal advice for people representing themselves in the Central District of California. We are located in the Roybal Federal Courthouse in downtown Los Angeles. Please visit our website or call our phone intake line for more information about our clinic. This is just the first video in our series overviewing discovery. Other videos in the series will cover topics such as requests for admissions, requests for production, subpoena duces tecum, and how to file a motion to compel. Please refer to our other videos for more information on the discovery process.